familiar faces there, which usually is a good sign of a quorum. So I will ask everyone's patience in advance. I have Zoom set up on my laptop in my car, so I'm doing the best I can. Haven't had any issues yet, and had a meeting earlier that worked out well. So we'll go ahead and get through this, but we'll go ahead and get started. I know Teresa can go ahead and do the member roll call.
Okay, we'll do. See Matt, good morning, or good afternoon, excuse me. It's been a very long week for me. Let's see, and Jill is here. And I don't see Marcy. I think she's excused for today. And Scott is here, of course. And Margaret, hi.
I'm here.
Okay, let's see, Tammy. Is not here yet. Okay, and Sarah. This is Sarah. Okay. John. And Lynn's here. And Patrick, is he here? Yep, okay. And Andrew, so I see down the logo. So we do have quorum.
Okay, so we'll go ahead and get started. Just a couple announcements. We had a little switch around in the order that we're going through. I think we have an updated agenda here that was sent out, so we'll go ahead and do LC 38 first and have a witness list with that. And we'll have, Teresa go ahead and call on people. We're going to try and implement a timing system where, Teresa, do you want to go over that real quickly, how that'll work, and you can show the cards?
Yes. So Karen and I worked on, based upon the witness list that we had from last week and who asked to testify today, in between that last Friday and today, divvied it up and have specific time frames. So I will announce when we start, the presentation, how many our allotted time for each of the witnesses, and so for the proponents. So, for example, on the first LC 38, we will give 10 minutes to Jess, and then we'll go from there. So I will keep time. If once you get to 1 minute, I will hold up a warning sign, like so. Although I need, I'll fix it because you can't see it. I mean, yeah, you'll hear the ding when your time is up.
So
am I supposed to go now?
No, if we can stick to that as much as.
So, Jess?
So yeah, you can go ahead and, I guess, Teresa, do you want to call her formally and
Yes,
then start?
I will. Yes. So so we're kicking off again with Jess Viatoro for Oregon AFL-CIO. And then Paloma Sparks is on deck.
Great. Thanks, Teresa, co-chairs, members of the committee. I don't have much to add from my testimony last week. I do want to just clarify, I forgot to mention the portion of the bill that does remove the employer threshold that provides discrimination and retaliation protections for employees that work for employer size 6 or less. So that is just one thing that I did not mention last week, regrettably, but I'm happy to answer any questions should you have any.
Scanning, I'm not seeing any raised hands or questions.
Mr. Co-Chair, I should also mention too that there is the bill analysis from the Workers' Compensation Division is on the MLAC webpage, distributed to the members, along with the other two LCs as well. So members, if you want to ask questions to the department, Sally and others are available to answer questions.
Do we have any questions on that, MLAC members? I see Tammy.
Just in regard to the bill analysis, it's my understanding, Jess, that I think it was David who said that they addressed some of the questions that DCB brought up, and that those were all resolved. Is that correct? Those are non-issues now?
Tammy, yes, SAFE and I met with the agency and we walked through all 4 questions, and my understanding is that there are not currently questions associated with them.
Thank you, Tammy. And I see Lynn.
This is in the dumb question category, but I see the bill is striking spouses living in a state of abandonment. What did that mean, or does that mean? Other than, I guess, the obvious, but.
This is so funny. I'm like used to the legislative format, and then the co-chair is Lynn. Thanks for raising the question. The way that we went about drafting it was to clarify that only one spouse can only receive the benefit at a time. Got rid of the cohabit plus one, or cohabit for a year plus a child, and then tied to the family law statutes. And I think the spouses in state of abandonment was to ensure that the one spouse in the new family law definition wasn't duplicating folks who may have had a previous marriage, etc.
Okay, so the new language just takes care of that generally. Okay, thank you.
Not seeing any other questions. Well, that was about the fastest 10 minutes of testimony we've ever had. So, Teresa, do we want to call who's next?
Yes, Paloma Sparks from Oregon Business and Industry.
Hi, co-chairs and members of MLAC, thanks for the opportunity. Paloma Sparks with Oregon Business and Industry. We're the largest and most comprehensive business association in the state. And we heard a lot in 2020 and 2021 about there being a hole in the retaliation statute related to individuals who inquire about their benefits and them not being covered in the way that the statute is written. So, you know, we were actually looking, before Jess brought this forward, we were looking for a way to address that problem. So we are thankful to AFL-CIO for working with us and making sure we got the language right, and feel comfortable with the changes on death benefits. So just wanted to let you know our position.
Great, thank you. Do you have any questions on that? Not seeing any. Teresa, see, it looks like Holly is up.
Yes. Oh, Holly Waddell from SAFE. I see Holly
actually,
there in the square.
Actually, on this one, Teresa, I was going to take this one.
Okay.
For SAFE. Dave Barrenberg from SAFE and Kevin Barrett, who is one of our trial attorneys, is also available, who works on death benefits if there are any technical questions. But just very quickly, we are fully in support of the bill. We think it makes a needed modernization to the death benefits component. And we hearing testimony in MLAC over the last 2 years, addressing issues with retaliation and intimidation of workers clearly is an important issue, and one that we think that MLAC should engage with moving forward. And we would be happy to look more into this issue, but this is a important issue. We support the bill and urge your support of this. Thank you. Oh, one other last thing, which was a big thanks to Jess and AFL for working this old school. And old school, I mean, is starting early, sharing drafts so we could work back and forth to perfect language, which in comp statutes sometimes takes a lot longer than you think it would. But so a big thank you to Jess.
So any questions about that?
And Mr. Co-Chair, that's all the witnesses I have signed up to speak to the LC.
So from the look of things, maybe A motion is in order. I would move to support LC 38 as submitted. I think if that's an appropriate format.
I'll second it.
So motion and a second. Do we have any discussion?
I guess the one discussion item was, we have all the different stakeholders here. We've heard no opposition to it. Is there anyone that's a holdout that hasn't said that they're opposed to anything, it seems? I just see little squares. I don't see everybody's faces, but I guess one last chance before we vote.
Not seeing anyone. Give it one more second here. Paloma?
Yeah, I've had some conversations with folks, and I haven't heard of any real concern. And I also ran it by my employment attorneys that I work closely with, and no one raised any objections to the language. So
I see Kirsten.
Hi, no objections. I wanted to basically echo what Paloma had said in terms of being glad that that AFL brought this forward to deal with issues of bad actor employers that are preventing employees from filing for the workers' compensation benefits that they're entitled to. So I just wanted to pile on to Paloma's comments from earlier. So thank you for the opportunity.
Happy to have it. Thank you. So I guess all those in favor signify by saying aye.
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 Any opposed? Looks like that passes. Great. I feel like we should all pat ourselves on the back for that one. That was, nicely done. It's a good way to get started on the new session here. John?
No, I was just clapping.
Sorry, I have my my brightness turned down here so I get as much life out of the laptop as possible. So it looked like a hand.
No problem.
Okay.
So it looks like next up on the agenda is LC 56, and I think Teresa has a list of witnesses for that as well.
I do. We do have some wiggle room. We're about 15 minutes ahead of schedule, so efficiency is a good thing. So our first panel is Giovanna Patrick and Keith Simple from the Trial Lawyers Association.
Yes. Thank you, co-chairs, members of MLAC. Thank you for your time here today. I'm Giovanna Patrick of Hollander, Levenbaum, Gannicott, and Patrick, she, her pronouns. I represent injured workers in Portland and around the state, and I'm also the co-chair of AWACA's Workers' Compensation section. So I'm here to talk to you today with my co-chair, Keith Simple, about LC 56, House Bill 4138, the Injured Worker Parity Bill. So injured workers rely on workers' compensation benefits to replace their wages when they're unable to work and to compensate them for permanent loss of physical capacity when their injury leaves them impaired and unable to work like they did before. Currently, there are barriers in the law that unfairly reduce these benefits and barriers to the worker's ability to go back and correct issues that affect those benefits. Insurers do not have the same barriers as the workers do. And the worker's ability to go back and correct and to plan is not in parity with the insurer's ability to go back and claw back benefits already paid. So this bill seeks to create greater parity. As representatives of workers, we see the worst situations, but we also see the routine situations that happen again and again to workers that deprive them of benefits under their accepted claims. And the biggest issues we see coming up again and again are workers with accepted claims whose time loss benefits or permanent disability benefits are unpaid or clawed back with no ability for the worker to challenge that, oftentimes with no notice to the worker so that they can properly plan. So the Worker Parity Bill seeks to remove those unexpected clawbacks to give workers timely notice and opportunity to correct deficiencies, to preserve some of the permanent disability award to workers so they can use that to rebuild their lives, and not allowing unlimited backdating of the medically stationary date that can create enormous overpayments against those PPD awards. So we're not talking about additional benefits here. We're talking about key benefits that injured workers would otherwise be entitled to, but for these surprising clawbacks that deprive them of those benefits. And so, just a little bit of background: when workers are injured on the job, the doctor may place restrictions on that worker, either light duty or no work at all. And the employer or the insurer then makes regular payments to replace those wage losses. And we call that time loss, or technically temporary disability payments. Once the worker says that, or once the doctor says that the worker is medically stationary, then that entitlement to those temporary payments stops. And any further wage loss that is paid is an offset against future benefits. And then the compensation that the worker would have gotten for permanent loss of physical capacity, that's determined under the law, that's often slashed because of these post-medically stationary payments and the large overpayments. And the real problem arises when the doctor concludes in hindsight that the worker was stationary months before there was any notice to the worker that they were stationary. And this enables the insurer to subtract all payments that were made after that new stationary date from the worker's permanent impairment compensation, even though there's no way for the worker to have worked during that time that the doctor still had them off of work. This often happens with doctors agreeing to an IME, with workers' restrictions changing with the stroke of a doctor's pen, with no required notice to the worker that their restrictions have changed, that their workability has changed, that their benefits have changed. This can unexpectedly deprive workers with serious disability of the funds they were counting on to rebuild their lives from their permanent disability award. Oftentimes, when a claim is closed with permanent loss of function, the worker is informed for the very first time by receiving that document in the mail that their doctor has declared them medically stationary and that there is now an overpayment, which will be deducted against that permanent impairment. These are workers with accepted claims that have serious injuries and verified loss of function due to their injury. And the overpayment accrues while they are legitimately off of work and receiving wage loss while they rehabilitate, with contemporaneous off work or light duty notes from their doctors that prevent them from actually working during that time. And then they're suddenly told, actually, you are medically stationary however many months later. Everything you've received since then is coming off of your permanent disability award. And workers have very limited abilities to challenge that and no ability to plan for that change. The worker cannot go back and suddenly work the past 3 months that they were off contemporaneously. And workers can lose thousands of dollars in their permanent impairment with the stroke of a doctor's pen. Workers should know when they're medically stationary, and no one should be able to go back months and months in hindsight and change the facts on the ground. These are workers who have done nothing wrong, and they are at their most vulnerable when their claim is being closed and their benefits are changing. And this crisis is particularly hard-hitting for low-income workers or severely injured workers who are most likely to use those PPD benefits to have job retraining, to rebuild their lives that have been permanently altered because of the work injury. So the bill does two main things to fix this first problem. It protects workers when doctors create an overpayment of temporary disability by backdating the medically stationary date, and it also preserves some of that permanent disability award if there is an overpayment, and limits it to 50%. So under current law, a worker's doctor is responsible for choosing when they're medically stationary. But when that date is given months after the worker is notified, that creates this huge overpayment, depriving the worker of the ability to actually work during that time or to plan for their return to work or return to some kind of work. Currently, nothing prevents an insurer from getting a doctor to backdate medically stationary to a past date, even all the way back to the beginning of the claim, while workers can only have doctors retroactively change their authorizations 14 days back. So one has all the way to the beginning of the claim, one has 14 days. This is not parity. The bill would limit backdating of the medically stationary date to 60 days to allow for some overpayment, but also allow for workers to more be able to plan for their lives. Also, when a worker is so seriously injured that they're left with permanent problems and sometimes an inability to return to their regular job, the law provides for compensation for that permanent partial disability and work disability. This is the money that workers and their families are relying on to rebuild their lives and oftentimes change careers through no fault of their own. Under current law, insurers can take back all of the permanent impairment compensation to recover an overpayment. In contrast, child support orders can only take 50%, and only 25% can be taken out of temporary disability benefits. But dollar for dollar, insurers can take all of the permanent disability benefits. And so for some parity and allowing workers to have some of that money that is intended for them to rebuild their lives, the bill caps that at 50%. Insurers can still collect their overpayment, but it's capped at no more than 50%. And then so adding to the problem of backdating the medically stationary date that we just talked about is the workers' limited ability to go back and fix mistakes in their temporary disability authorizations. So insurers can go all the way back to the beginning of time to fix mistakes and reduce the workers' benefits. But currently workers only have 14 days with no notice requirement to fix deficiencies in their temporary disability authorizations. These are problems with where the doctor maybe wrote a note, maybe forgot to, maybe the appointment was missed. There's lots of reasons this happens, but workers have no notice and sometimes no understanding that there's a problem until they miss their first check, and now it's been over 14 days and there's nothing they can do to fix it. So the bill does a couple of things to solve this problem. The first is that it requires insurers to notify workers when their temporary disability benefits are ending. So right now, as I said, the worker might not find out until their check doesn't show up. And then they're scrambling, calling the insurer, calling the doctor, trying to figure out what's wrong so that they can get that much needed wage check. And that 14 days is a hard deadline right now. No excuses, no explanations. It doesn't matter if the worker doesn't know there's a problem, whether the doctor made a mistake, whether everyone agrees that worker is off work. That worker might be post-surgery in a cast. If they don't have that note in place and they don't fix it within 14 days, they don't get paid their wage loss. Period. End of story. No explanations are accepted. So we want notice, and also this bill for the workers, notice to them so they know what's going on, and extending that backdating period from 14 days to a much more reasonable 60 days, similar to the backdating medically stationary time. And that's 60 days after they have noticed that it's wrong or that there's a deficiency, so the worker can correct it. Workers should have a reasonable amount of time to correct these deficiencies. This is even more important now with COVID, as we know that there's a new reality in the medical field. Access to doctors is becoming very problematic. It is hard for workers, for anyone, to get into a doctor. So we don't want to make it harder for workers to get in touch with their doctors, get their restrictions, and fix those restrictions. We don't want workers panicking and calling their doctors in the middle when they don't have an appointment trying to fix a restriction. They should have a reasonable time to fix that. And what we're talking about here is the most important benefits for a worker in an accepted claim, the ability to financially provide for their families while they recover. And so why would we allow these got you moments for workers with compensable claims, creating periods where they don't get their time loss benefits, even when everyone agrees they were legitimately off of work, due to these harsh deadlines that are not tied to the care that the doctor is providing? So as the workers' attorneys, we're the ones that they call when that check doesn't show up. And we're the ones that hear that they can't pay their rent, they can't buy food for their families, they can't afford gas to go to medical appointments. We hear these stories every week, every day from our claimants, and that's what we have brought this issue as well forward. There's a few other things that the bill does I'll just touch on briefly. It also creates an exception to the need for an authorization during the time that the claim is in litigation, because when the claim is denied, it can be very hard for workers, even workers with health insurance, to get in to see doctors and get those restrictions. And so there should be an exception during that time and a reasonable amount of time afterwards for workers to fix those restrictions once litigation has finalized. And then there's also another thing about parity is giving workers and insurers the same amount of time to go back and discover errors. These are errors such as disputes about the average weekly wage, the rate the workers are paid at, or the failure to make a specific payment that was authorized. Right now, insurers have unlimited time. They can go back to the beginning of the claim. Workers have 2 years. So we're proposing taking out that 2-year limitation and having parity between the insurers and the workers. So it's our expectation bringing this that MLAC is a problem solver. So we've identified this problem and we're asking for your help in fixing it and solving it. And now I'll turn this over to Mr. Semple to continue OLA's presentation on the bill.
Thanks, Giovanna. I basically wanted to just recap the history of this concept in these discussions. We started with a major omnibus bill in 2018, and we were understanding that that needed to be pared down and narrowed. We brought the current concepts forward to the forefront in 2019, and in 2020, we shifted discussions to COVID presumption, and that really took up the bulk of 2020 during the summer and leading up to the session to discuss that bill. We did bring a bill in 2020, and that contained the concepts essentially that we're bringing forward now, and we were unsuccessful in the 2020 session. We were told basically that we needed to re-engage with the other stakeholders and discuss some of the other things that had been raised. We did that throughout the summer of this past year. And basically what we came to is that the defense is most concerned on their end about open-ended work restrictions. And the work restrictions they define as open-ended are those that aren't attached to a specific date that's within 30 days of when they were issued. So the open-ended work restriction concern that's been raised in response to our concerns, the basic argument is that if workers are engaged in their treatment and seeing the doctors every 30 days, there won't be any surprise overpayments or problems on their end in terms of surprises. So the response was that work restrictions should expire every 30 days, regardless of how they're worded. So if the doctor says that the work restrictions go on until the follow-up after the MRI or the follow-up after the specialist consult, those would be invalid to apply beyond 30 days of impairment. So basically the workers would be cut off on day 30 every month unless they could get the restrictions they need from their doctors. That was the response essentially, and the response I expect to hear after we give our testimony to the concerns that have been raised by the defense. This places an extraordinary burden on the doctors and the workers, especially the workers. The workers don't control the work restrictions. The workers don't control whether the doctor gives them in a way that gives a 30-day duration and the worker gets to see the doctor in 30 days. Sometimes the appointments are canceled because the doctor's out of the office on vacation. Other times the doctor decides that regardless of what the worker thinks, they will tie the work restrictions to the date of the MRI or the specialist consult. Sometimes there are reasons beyond the worker's control that prevents them from going to medical appointments. The proposal that we've received in response in the discussions we had over the summer was that the work restriction should expire on day 30 regardless, and that the worker should have a window then to go back and correct that with the doctor within a certain time frame. But the benefits would not be payable until that occurs. That is a major shift away from the parity types of proposals that we're talking about in our concepts and in our legislative proposal. We think that the idea of limiting work restrictions to 30-day duration, regardless of what the doctor says, is a major issue. It's not an add-on to the discussion that we're proposing. It's more akin to what the firefighters are discussing and the discussion that's been surrounding their concept, which is basically to relitigate the entire concept of a presumption. In the past discussions at MLAC, I realize that we've got new members. In all prior discussions that will be held up as models for how we have this discussion, the discussion's been limited to the legislative concept and the legislation that's being proposed. The prior experience with MLAC has not been that the stakeholders are just, basically ordered to go back and have a discussion amongst themselves, and other issues can be raised and inserted that potentially could derail the discussion. The concepts that have been discussed are the legislative proposals at hand. We, as Giovanna indicated, we hope and expect that MLAC can help be problem solvers here, But we don't expect to have success in this discussion if we're going to add on additional concepts that are major departures from the current law and discuss that in terms of what we're trying to do to create parity. So we really would like the discussion to be focused and refocused on the legislation at hand, as opposed to there being some expectation that we're going to kind of meld other concepts into the legislation that we've proposed, the legislation that our representatives are sponsoring. So I think that the best way forward is to refocus that discussion. We did review the analysis of the bill. There's a lot of good questions in that, questions that we're looking forward to discussing and trying to hone the bill and tailor it so that there's no unintended consequences. But that discussion doesn't happen if we're focused on other concepts and things that, quite frankly, we won't agree to, because that just sets another trap for injured workers. Our whole concept here is creating parity and trying to eliminate some of the surprise moments that are happening for legitimately injured and disabled people. And the idea that we would set a 30-day trap for the worker to have to go and fight with their doctor to get the work restrictions they need. I mean, I can only imagine these conversations that are going to happen between the worker and the doctor's staff on day 28 when they don't have restrictions in hand because the doctor's on vacation. I mean, that is not going to help the workers' continued treatment, and it's not going to help keep doctors in the system agreeing to work with injured workers. It's likely to result in workers not being able to continue with a particular provider and having to find a new one. So we would like to refocus the discussion. We're asking for your help in doing that. And that's all I have to say. Thank you.
So I see a couple questions coming up. I saw Tammy first.
Okay, thank you, Scott. Thanks, Keith and Giovanna. I have a few questions, one for each of you. I lost Giovanna on here. Oh, there you are. Hi. Okay, so I want to talk first and ask, please, about telemed visits. I don't see anything in the rules. We have our workers that will, be able to have a telemed visit, especially during COVID. There's nothing in the rules that prevent that. Is that correct?
No.
Yes, okay. That's correct. Telemedicine visits are perfectly acceptable.
Great. Okay, I want to talk about the open-ended time loss issue and cutting off time loss for the workers, because as a claims adjuster, that what you guys were saying isn't really my understanding. My understanding is that there's really only 3 ways to terminate time loss, excluding the going through the department and the suspension of benefits aspect. Otherwise, the only way you can terminate time loss is, 1, if a worker, if you issue a valid job offer after a light duty release and that's sent certified mail. Number 2 is if the doctor declares them medically stationary and releases them to full regular work. Or number 3, they fail to respond to the 14-day bug letter. So is there a 4th way, excluding the suspension of benefits, or a denial? Obviously, a denial would stop interim compensation. But is there a 4th way to terminate a time loss, please?
I would say that the most important way is the first way that you described, because the concern is that the employers will be unable to bring a worker back to work when they want to and be forced to pay insurance benefits and not see the worker or know what the worker is doing or how they're doing. The employer, the insurer, the self-insured employer can send the doctor a request for approval of a job that's within the worker's benefits at any time they want. So, one concern, the doctor, the employer can send the job description that's within the worker's restrictions at any time they want. Let's say that an employer doesn't quite have a job description that's within the worker's restrictions, but does have a job that's 5 pounds more. And the worker has missed their 30-day appointment and the insurer and the employer want to know, can the worker do just a little bit more? They can contact the doctor with the job description and say, hey, you know, we think that the worker may have improved even though they missed their appointment. Can you agree to this job? And the doctor has the ability to respond and agree to that. And some doctors will respond routinely to these types of questions without consulting the worker. So there's an ability there to cut off benefits by offering a bona fide job within the worker's restrictions. Let's say an employer's not. Go ahead.
No, I was just gonna interrupt you for a clarification point. So in that example that you gave, the employer didn't have a job within a 5-pound restriction, but a few weeks later they were able to get the doctor to increase that from 5 pounds to 10 pounds, and now they can send out the valid job offer, and then the worker has 14 days to reply. Is that correct?
I don't think it's the 14 day. I don't think they have 14 days to reply. I think they can be given a start date. And if they decide not to start the job after receiving the notice of the job and the fact that the doctor had agreed to it, then they get offset for their wage loss.
Okay, so just failing to go to a doctor's appointment. Let's focus on that for just a second, please. So if they fail to go to a doctor's appointment, I called the doctor's office today and my worker no-showed yesterday. I can't cut off time loss from yesterday. I have to send a bug letter if it's been 30 days. Let's go through a real life scenario, Keith. Let's say the worker's last doctor's appointment was December 1st. So in January, I called to see did they attend their follow-up appointment, and here it is January 10th, and they've had no medical care since December 1st. I can't cut off time loss at that moment. I have to send a bug letter giving the worker 14 days to reply. And if the worker says, yes, I have a doctor's appointment scheduled for February 10th, then I can't cut off time loss. I have to continue all the way to February 10th, even though they haven't seen their doctor since December 1st. Is that the correct scenario? Am I doing this right?
No, I would say that the best approach for you in that situation would be to send the doctor a bona fide job offer based on the restrictions that were given on December 1st, or maybe slightly less onerous restrictions, and see if the doctor will agree to the modified job. Okay. You know, we're assuming that we're assuming that there's no job being offered based on the December 1st restrictions.
Right. On December 1st, right? It was full time loss. Full time loss is authorized, no light duty.
Okay. So we're talking about a subset of workers who have been restricted to no work whatsoever, really.
Yeah, right.
I mean, we're not necessarily talking about a worker whose restrictions were clear on December 1st, and the employer had the ability to offer a job within those restrictions on December 10th. We're really talking about more the workers who have been off work with no work being authorized. And what the employer can do in that situation is send the job description to the doctor that basically is showing up at the work site and sitting in a chair and observing other workers. I mean, there's no floor to how low and how minimal a modified job offer can be. You're able to ask the doctor, okay, can they show up? You said that they can't work whatsoever. What if we make a job that the worker, all they have to do is show up at the work site? That option exists, but employers don't make use of that option most of the time.
Sure, I agree with you. I'm just talking about the ways to terminate time loss, because as far as I know, there's really only 3 ways to terminate time loss on an accepted claim, plus going through the department with suspension. And it sounds like that's correct. In reading your bill, in all practicality, when I'm going through it, it looks to me like a worker could actually receive 90 days of time loss off of one doctor's appointment and get 90 days of time loss, and they only went to the doctor one time at the very beginning. I don't understand how this bill would actually help an injured worker get better. I mean, maybe they need an MRI. Maybe they actually have a partial tear or a full thickness tear or something. I don't understand how 90 days of no treatment is good for an injured worker.
I think that that's not a correct understanding of our bill. Currently, the doctors can give the work restrictions any way they see fit. If they want to say that a worker is off work until further notice, they can do that. If they want to say a worker is off work until they return after the MRI, they can do that. Even if the MRI takes 90 days, even if the MRI takes 180 days. Realistically, workers are trying to get better and seeing their doctors. So there's a very small subset of workers, I suppose, who are trying to evade their doctors and not actually participate actively in their treatment to try and get better. And I understand that that subset of workers is a major concern. It's a concern for us too. We don't advise our clients to avoid their doctors. We don't advise our clients to skip their appointments. But to the extent that we're focusing on open-ended work restrictions, meaning work restrictions that expire in a date later than 30 days or aren't tied to a date, again, those are within the doctor's, that's the doctor's decision to give the work restrictions that way. The doctor can put a 30-day end date on the work restrictions if the doctor sees that is the best way. Some doctors do. Other doctors leave it open-ended. But the way that we're talking about this forces the worker to be the police person of the doctor. And we're assuming when we talk about this, we're treating it as though all of these situations arise when a worker is trying to avoid treatment. Situations where the work restrictions and the worker is going past 30 days to get the work restrictions do not always arise because the worker is being inactive and avoiding the doctor. And we're talking about this, again, this is a different topic than we brought forward in our legislation. I understand this is the topic that the defense most wants to talk about. But again, we're talking about something that actually isn't in our legislative proposal. Our proposal doesn't expand the ability to do open-ended work restrictions.
Well, it's the 60-day issue that's an issue. And I do want to talk about generally, Keith. I would like to talk just 1 minute about generally, and then other people have questions. There's about 6 or so things in your LC that, we're looking at those 6 changes. And a couple of them we have no problem with. I have no problem with. A couple of them seems like to be asking for the moon, and maybe we need to get down and negotiate and get a acceptable figure for both management and labor. And it's my understanding, and we would have to go back to the minutes from February and March. It's my understanding that the stakeholders on both sides were going to try to come together throughout the summer and fall. So right now, we could be having in front of us a bill that all parties agree with and that we're just going to vote yes on and we're done. I don't see that has happened. And I'm wondering if you guys are willing to talk to the stakeholders and talk to SAFE, the other side, because a lot of these things we have no issue with. We're in agreement that some changes are made, and then some other ones we need to kind of narrow down some of these dates where we have our concern. Are you guys even willing to talk?
With due respect, we spent a lot of time over the summer talking, and where we've come to is the idea that in order to reach a compromise, we need to limit work restrictions to 30 days, regardless of what the doctor says or what happens on the worker end. That's our understanding. There's been a lot of discussion, but we understand that. I was actually at these discussions, Tammy, with due respect.
That's true. But that was never the intent, regardless of what the doctor says. Obviously, we wouldn't do anything regardless of what the doctor said. Okay.
The proposal that was presented to us over the summer was that work restrictions would expire on day 30, regardless of circumstances. And in order to get some compromise on a litigation exception, and there being a little bit more than 14 days for work restrictions to be revised, that the quid pro quo would be that work restrictions expire on day 30 regardless of circumstances. We rejected that. We continue to reject that. If that's the status quo, if that's the best that we can do in these discussions, then the answer is, I guess we'll live with the injustices that workers are living with right now, because we're not going to set a new trap for workers on day 30, and we're not going to set up a dispute with workers and their doctors on day 30 if, for whatever reason, the work restrictions aren't in place. That is where we ended discussions, and that's where we stand right now.
So let me
Okay,
jump
so-
in and give Sarah a chance to talk, and then Tammy, we can circle back in just a minute, maybe, if that's okay.
Yeah.
So Sarah, go ahead.
Yep. Thank you, Scott. Thank you, Giovanna and Keith. I just have a couple, hopefully quick questions. We talk a lot about parity. Would you support a 2-year limit for insurers to review time loss and keep the 2-year limit for workers?
I would, sure.
Yeah, we're looking for parity here, and if that makes more sense for everyone, that's perfectly fine.
Okay, great. Thank you for that. And why is ensuring regular contact between an injured worker and their medical team a problem? I know the 30-day, but with telemedicine, I heard extraordinary burdens, and I heard a 30-day trap. But with telemedicine, there's a lot of burdens that are overcome just by that, and a check-in could really benefit the worker, could it not?
We completely agree. If my client asks me how often should I see the doctor, I would tell them as often as the doctor wants to see you. What I don't want is my client telling the doctor how they need to give the work restrictions, how often they need to be seen, on pain of my client losing benefits. That's not fair to injured workers. They can't tell the doctor what to do. It's been noted that workers have a difficult time finding a doctor, and we had a hassle factor discussion several years ago about why doctors don't want to participate in workers' compensation. We do not want to discourage workers from seeing their doctors, and it really troubles me that the assumption is that there's a broad problem of workers not trying to get their medical treatment and get back to work. I don't doubt that there's a subset of workers who evade their doctor and try to find some way to game the system. I can say in 18 years of doing this that I do not see workers doing that on a regular basis. And there are ways that insurers can deal with that problem by contacting the doctor and asking for a bona fide job offer and things like that. So
Keith, I hear you. Thank you. I understand what you're saying, and that's not what I'm saying at all. I was just asking if more regular contact, if you'd see that as a benefit for workers, and I heard yes. So thank you. Those are my questions.
Thank you, Sarah. And I saw Lynn and then Matt.
Thank you, Scott. Hi, Keith. So as I think about how MLAC in the past has approached having both sides work together, it is really because we want to find a compromise, and we know that you, the different parties working together, are going to get better language than we would get. And so, frankly, that's why I would like to see the parties go back and find language you could live with. And I hear what you're saying, but I can't imagine there isn't some language that both sides couldn't live with in this regard. I mean, I would imagine that the proponents of the limit on time loss could go and get an amendment to the bill, assuming it fits in the relating clause, which I believe it does. So I would really like to see the parties go back and try to talk it out so that we on MLAC can be comfortable that both sides are getting what they need.
This is Giovanna, we don't have a problem continuing discussions if they're focused on our bill and tailoring the language of our bill, just like he said that we're working out to make sure that there's not unexpected consequences. What we don't want is to go back to the same discussions we had all last year, where all we got was, we won't talk about anything on your bill until you guys agree 30 days forward, and we'll give you an extra 16 back. We won't address other things. That's not productive. So if the discussions are productive and addressed to our bills, that's fine. Continuing discussions about topics that we can never agree to is not productive.
It's the classic poison pill. I mean, that's what this is. I mean, we all know what that is. You introduce something that the other side absolutely can't agree to, and you derail the entire discussion, and you get off the merits of what was being discussed, like backdating medically stationary dates, and you get down in the weeds on what can we do to limit doctors from giving work restrictions in excess of 30 days. I mean, if that's the best that MLAC can do as a problem solver, that's really unfortunate.
And I see Matt.
Thank you. So I'm new to this, so I could use a little, maybe a little history, but I could use to understand why it's only physicians, one, who get to, or am I clear? It is only physicians that get to determine the time loss, right? And some of the terminology used, I'll probably stumble through, but it could not be an advanced practice registered nurse. It's only physicians, DO or ND. Is that accurate?
It's very complex. There's actually a chart that's produced to apparently help injured workers understand who can authorize their time loss and when. I mean, Giovanna and I understand it because we've been doing this for 10 plus years, but I'm not sure how a worker would navigate that. But yes, there's a chart. It's not always just MDs. For a period of time, chiropractors can do it. Under some circumstances, a family nurse practitioner can do it. But it's very complicated. It's a trap for injured workers. It's another trap that our legislation doesn't address.
Okay. Because I guess that was what my understanding was, there was some restriction on it. And that was because there was the belief that that level of professional DO or MD would really be the kind of negated the concern about we need to put a 30-day time limit on it, because MDs and DOs have this level of education where they have the judgment and the understanding that they, maybe it's going to be 45 days, maybe it's going to be 60 because of the things that they went to school for, right? That they understand how to do. So it just feels like there is a litigation going on here on an issue that would be resolved by allowing the professionals in the field to have to determine the time. So it does feel like an odd connection between what I read, and maybe someone can help me make that connection. This LC, looking at it, I don't quite understand how finding this parity relates to then restricting the provider's ability to determine the timeline. And so as a nurse who is seeing how healthcare works, I would say, sure, there's right now we have an insatiable need for healthcare in our society and we cannot meet it. And so, restricting in this way with a timeline to increase the burden on our healthcare system to me is concerning. And then when I hear things about telemedicine, it is helpful. It's probably not as amazing as folks think. And there's also a lot of issues about access to telemedicine. It tends to fall towards people who are in a higher socioeconomic status. So it's odd to me that we're looking at the parity, and then so can either of you help me understand this connection between restricting the physician's ability with this 30 days and how that matches the parity? I'm struggling for getting that. When I hear the argument that I read the LC and then I hear this argument that this is all connected to saying that you have to have your appointment within 30 days, which, that is reasonable, but there's a lot of situations. Go try to book MRIs, go try to get your labs done, and then have the physician have time to review it. I work in the industry. It's not going well. So it seems like this would increase the burden there, which could actually, there's a chain of effect from that. So anyway, can neither one of you help me connect that?
I can't really help you connect that. I mean, that's really a question for the insurers and self-insured employers, because, really you're telling a surgeon, potentially, that they need to see the worker before they think they need to see the worker. So the worker needs to go and see them in order to get work restrictions. And I suppose the response might be, well, why can't they do a telemedicine? Why can't they just get the surgeon to update the work restrictions without a visit? The worker does not control the doctor. So you put the pain on the worker and you pit them against the doctor on pain of not being able to receive the wage loss that you're needing to provide for your family. The question is a good one, and I don't have an answer. I wish I did. I don't understand it either.
And, to your question about, the types of providers, a lot of this was already fixed. The concerns that the insurance industry has was already fixed by prior, rule changes, prior laws changes, where chiropractors can only authorize for 30 days, emergency room doctors only 14 days, nurses only 180 days, physician's assistants not at all. So we've vested this with the doctors, people who have the know-how, the expertise to really evaluate this, and we don't want to take that away from them. Imagine a surgeon writes 6 weeks, come back and see me. Well, now we expect the surgeon and the worker to know that 6 weeks isn't good. It ends on day 30, even though everyone wrote that that's not necessary. And so it creates traps for workers. The 14 days back also creates traps for workers. Because I can tell you, my workers always say, I saw my doctor. I see the note. It's signed by a physician's assistant. It's signed by a medical assistant. 14 days might have already gone by. Even though the doctor saw them, they didn't put their signature on that note. The worker has no idea that it's not a medical doctor. And now the worker can't do anything about it. That's where the 60 days comes in, to go back and fix things like that when the worker doesn't quite get the right authorization. But when it comes to the doctors, the MDs and the DOs, we give them so much power in these claims. They have the power to say if you can work, what referrals you get, if you're medically stationary. Why would we question their authority on how long the worker needs to be off? It doesn't make sense.
We're kind of starting with the proposition that workers who are under work restrictions are not legitimate after day 30 unless proven otherwise. I understand there's a subset of workers who are not keeping up with their doctors and skipping their appointments and flaking out, but you're treating all workers, even those with very severe limitations, as though they're gaming the system after day 30 just because their surgeon said, I don't want to see you back for 6 weeks. Talk about throwing out the baby with the bathwater. This is extreme. This is an extreme thing to suggest. And it deserves its own set of discussions. And we've got a lot of questions and a lot of data suggestions and a lot of other things to talk about with this proposal. But it's not right to derail the discussion of backdated medically stationary dates and these overpayments that are just devastating to injured workers. It's not right to derail that conversation with a much, much bigger conversation about the equities and inequities of forcing the worker to have work restrictions on day 30 or get cut off. Realistically, the worker's not going to know, and they're going to get a huge overpayment at the end of their claim when they find out that they're permanently disabled. And that's how this money's going to be clawed back. They won't be told on day 32 that they're not eligible for time loss. Maybe they will, and that'd be awful, to just cut the payment off. But if the payment's issued, we can just get it back later. If that's the proposal, that's the proposal, but we're a no on that.
So, and I'd like to, as a now medically stationary worker who's been through this process and fought through it and had to go through all of these things that we discuss and fight to go in to be able to see a provider, make sure that I was getting updated work restrictions and work releases and other things like that. I definitely want to hear more on this. And definitely want to kind of remind everyone that our focus here again on MLAC is, we have these common set of values that we're kind of committed to viewing through all the analysis that we do through this lens of balance and fairness, adequacy of benefits, affordability, efficiency, stability and flexibility. So all of these kinds of things are how we're supposed to be perceiving our analysis, and I have not heard much about that in the questions that have been asked outside of a few of these issues. So I'm interested. I want to, maybe we can move on to another speaker. I have some questions kind of bubbling away on the back burner of my brain, but maybe we can move on here from the other side a little bit, and then I can follow up with some more questions if everyone's okay with that.
Thanks for your time.
Thank you.
Thank you much. So I think Teresa, if we have next.
Yes, we have Paloma. And then Kirsten, are you joining Paloma or are you separate?
I think we're going to do it separately. I think similar sentiments, but I think we're planning on going separately.
Okay. Okay, Paloma.
So you're calling me?
Yes, I am.
Okay.
You have 7 minutes.
Thank you.
Sorry.
I don't think I'll need that long.
Okay.
I think you've heard some of our concerns about wanting to make sure that, our system is not just about payments and money. It's also about making sure that workers get better. And that's what we want to see here. So our concern is that, creating more sort of open-ended and longer time between when a worker needs to see their doctor is particularly concerning to us. Additionally, I would say that the Medical Advisory Committee had the same concerns, that they wanted to make sure that workers were seeing their doctors or their healthcare providers on a regular basis. And from their perspective, the 30 days made the most sense. So we do continue to have concerns about this proposal and how it's been structured, and that it doesn't address open-ended time loss.
So I guess a question that I have is, there's nothing that changes on the time loss under the proposed LC, correct?
No, it changes the amount of time of limiting retroactive time loss. It changes the current timeline.
But for because you raised the concern about sort of prospective approval, that we've heard about, but there's nothing that changes what the current law is in the proposed LC, correct?
We have consistently been asking folks from trial lawyers to have this conversation with us about this and have not been able to get any success.
Okay. I guess I'm a little confused because it seems like the concern is that this doesn't address an issue that it's silent on. Am I correct in understanding that?
And our ask is that if we're going to make these sort of fundamental changes that impact time losses generally, we should also be addressing this other issue related to time loss.
And is there a reason why you wouldn't bring your own separate bill to do that?
Because this is the bill related to time loss right here. And it certainly seems unfair if the tables were turned and we had a bill that other huge stakeholders in the process wanted a change to, it would seem reasonable for them to be willing to work collaboratively with us on a problem that we also identify in the same area that they have identified.
And I understand that. If this has been on the back burner for 2 or 3 years, it's just surprising that if there has been no movement or discussion from OTLA, that there hasn't been anything else brought as an alternative. That I am just curious about that, but I don't want to dominate the discussion here. So I see Matt and then Tammy.
Well, I would follow up with kind of the same question. I'm having this proposal doesn't have anything that addresses. It's not changing that process at all. Am I not seeing that right? I don't see this. As Scott mentioned, it's silent on that one process, and then it seems like it's bringing parity for the worker is its intent, and it. So I guess I'm misunderstanding where you see the connection of limiting the physicians, or making this 30-day limit, and how that plays into the timelines within the proposal, where those are connected. It seems like it's silent on the component that you keep bringing up.
So, I'm not sure to which piece you're referring, but I would say a year ago when we had this conversation, the expectation was that both parties were going to work together and reach a compromise and negotiate. And we've been trying to have that negotiation and compromise. And, there's a lot of changes that the trial lawyers would like to put into new legislation impacting time loss. We have some requested changes, and we'd like for them to be willing to have a reasonable conversation with us about those concerns.
So I see Tammy and then I see Lynn.
I just kind of wanted to address both you and Scott, Scott and Matt, just in some of your comments or your questions. And Matt, you were asking about the time loss, how this affects the time loss and why we're so focused on that. And it's because if the worker doesn't see the doctor every 14 days or a compromise of, like every 6 weeks or something, they can truly have one doctor's appointment and 90 days of time loss. And that just seems like it is very unfair, in that if we could come together and talk about a more compromised number, that would be awesome. And then also, being on MLAC for quite a while now, I was there when this was first brought up. I was there when it was kind of set aside to do COVID. And then I was there when we said, okay, let's get this through in short session, have the two parties come together and come back with language that both agree upon. And that has not happened. It doesn't really matter, he said, she said, and both sides pointing the fingers at each other. I just kind of want to bury that under the bridge and have we start fresh, because I know that on the management side, they do have their own language. They do have their own LC, but why should we have two battling LCs when surely we can come together and reach something that both parties are all in agreement upon? And so that's what I'm hoping that happens. Okay, enough from me.
Thank you, Tammy. And I see Lynn next.
Yeah, I was just hoping, I don't know where it is in the witness order, but I think it would be helpful to hear from SAFE, or, hear SAFE's take on some of these questions that are being asked.
I think that's a great idea. That's why I tried to cut it off a little earlier so we could hear a little more from the other stakeholders. So I'm not seeing anybody else for right now. Teresa, do you want to bring the next
Yes.
witness?
So we have Kirsten, and then SAFE is right after Kirsten.
Good afternoon, MLAC members. I apologize for my wonky camera angle today. But I want to echo a lot of what Paloma said. I think that, there's a lot of sort of the more technical details that SAFE and some of the other defense attorneys that are on here can cover. But for us, we, are looking at things for more policy than sort of the technical, since that's more of our area. And you've heard this said before, but our biggest concern is making sure that there is consistent treatment for injured workers. We think this is best for the system, and if workers are able to heal and return to work. And so we have a concern that quadrupling the days where there can be retroactive time loss doesn't serve that goal. And I know one of the main conversation pieces swirling around here is the issue of open-ended time loss, and we really see that as linked. And I understand that is not in the LC that's being discussed right now, but I think this goes to what the management side, it sounds like, is hoping for, that there can be a discussion to reach a compromise. And I think that if you're looking to reach a compromise, it's not always just what the one side has put on the table. You need to have a discussion of the issue as a whole, and I think that's where this open-ended time loss issue comes in, is that it is goes to that broader conversation beyond the just looking at that's the retroactive time loss. And I'd also like to echo what Paloma said about the Medical Advisory Committee. I think that that's a really important piece to take into consideration here, that when this issue of open-ended time loss was brought before them, they were, for the majority, in agreement that 30 days was a good recommendation. So you have the medical professionals that are doing this work saying that is an appropriate amount of time, and some of them were surprised that that's not already the case. So like I said, I'll leave the technical pieces to the attorneys, and I think it'd also be helpful to hear from Elaine on, in particular, some of the negotiations that went on, because I think we have a very different view of how that went, and I think that that would be a good thing to talk about as well. But that's sort of more her, so I'll leave that to her. But thank you for the time.
Okay, if there's not any questions, I
I'm not
see Elaine's on.
others that we can discuss.
Okay.
There we go.
Okay. So I see Elaine and David. Is Kevin joining you or? Okay. Okay, Elaine.
Oh.
David.
So I'm Dave Barenberg from SAFE, and with me is Elaine Schooler, one of our trial attorneys, and I am here to help with some questions and issues. Elaine will be doing the bulk of presentation. She has been engaged with the process from the outstart and the negotiations on behalf of SAFE, as well as being one of our trial attorneys, so is day-to-day working with these cases. So Elaine?
Yes, thanks, David. Good afternoon, co-chairs and members. I'm Elaine Schooler. I'm an attorney for SAFE Corporation, and I'm here today to talk with you guys about time loss and what we're also seeking as a compromise and solution to the issue that's being addressed in LC 56. Just by way of background, time loss is compensation paid to workers when they can't return to work with their employer during the course of their recovery for a work-related injury. And there are two kinds of time loss. There's temporary total disability and temporary partial. Temporary total means the worker can't perform any type of work at all. The doctor just says you're off work completely, and that starts the time loss benefits. Temporary partial disability means the worker can perform some work, and for time loss to be paid, it means the employer can't accommodate those restrictions. And so time loss benefits are again paid in that situation at the same rate as the temporary total. And time loss must be authorized by a medical provider. And currently there are no time limits as to how long the provider may authorize that time loss, nor a standard as to how often the provider should be reviewing the authorization for appropriateness. The solutions that have been presented to you in LC 56 address one piece of this time loss problem. The solution addresses retroactive benefits and their recovery. There remains a blind spot in the system, though, because while they address surprise with overpayments and limiting the recovery by providing additional notice requirements and limiting that recovery, what we want to prevent is the overpayment from occurring by supporting increased contact between the worker and their provider. Now, it's important to note that the prospective solution that we're seeking isn't one that's tied necessarily to a medical visit, but it's tied to that contact between the worker and their medical provider to ensure that restrictions remain appropriate. The reason for this is simple. Workers have better recoveries when they receive timely and appropriate medical care. And we want to ensure that that regular contact is happening, that there is a dialogue when workers aren't able to get back to work or have modified releases that cannot be accommodated. This is really a common sense standard for workers who have been off work. It's also easy to communicate as one that makes sense to those treating injured workers. There have been some discussions about the past discussions with the trial lawyers. And it's true, these discussions have occurred for a long period of time. And it was with MLAC's encouragement that the parties get together, work towards common solutions, and come back to MLAC with language that both parties could support. As part of that discussion, we did reach some agreement. We did have some common ground that we could find. There were comments that we wouldn't work with the trial lawyer's proposal, but that simply isn't accurate. We agreed to increase the days for retroactive releases beyond the 14 days. Our initial proposal was 30 days that we were willing to go to, and OLA's desire is for the 60 days. Still, we're willing to compromise on that and agreed to compromise on that. We also agreed to providing additional notice to workers, and that was a good thing so that workers aren't surprised. We agreed to excluding denied claims from the procedural requirements for time loss, but that was a fundamental issue, that workers whose claims have been, been denied are not tied to the restrictions that apply to accepted claims. Now, we got to that point, we said, hey, we have a solution too. Here's a piece that we think will help provide clarity provide consistency, and ensure appropriate contact between workers and their providers, and that work restrictions are being timely addressed and remain appropriate in that workers as part of that workers' care. And as we had that discussion, the suggestion was made to take this to the Medical Advisory Committee. Now that's a committee like MLAC. It's comprised of medical providers, though, rather than management and labor. And these are medical providers who practice within the area of workers' compensation. There are private practice physicians. There are MCO MCO participating physicians. And when we took to them this idea of open-ended work releases and whether doctors should be addressing work restrictions on a more timely basis, different time periods, the doctors were surprised to hear that there even was such a thing as open-ended releases. And the doctors' comments ranged from time periods of 14 days to 45 days for work restrictions to be addressed by a worker's medical provider when they're receiving time loss benefits. The majority of the MAC members thought that 30 days was an appropriate amount of time for workers to maintain regular contact with their provider when they're off work. And that's what we're really seeking here, is a joint solution that addresses those retroactive benefits, to eliminate surprise, to preserve some benefits that workers are expecting, such as their permanent disability awards, but also a prospective solution, one that ensures that workers are maintaining contact with their medical providers, that workers have clear expectations of their role in participating in the system and in getting back to work and being a participant in their recovery, and that the medical providers too know that they should be having that regular contact with their patients, and that's really a best practice and a best standard of care for workers as they navigate through their recovery. Our negotiations or our discussions with the trial lawyers really broke down following that piece. We agreed to exchange language in the fall, around August, and shortly after exchanging draft language of their proposals and ours, the trial lawyers were no longer willing to talk about our idea and our proposals. Instead, they wanted to move ahead with their bill that only addressed their issues. Then, in fact, we reached out to the trial lawyers again early this week saying, hey, we're here and we're willing to engage. And again, we're met with the response that they weren't willing to participate and engage with us unless directed by you, the MLAC members. At SAFE, we truly remain committed to helping injured workers recover and return to the workforce. We're committed to working with our partners to find solutions to further this goal. And our willingness to support many of the ideas proposed by the trialers in LC 56 is evidence of that commitment. We hope that MLAC can support proposals brought forward by all parties and ask us to go back to the table and continue the discussions that ended abruptly in the fall. You are the problem solvers, and there can be more than one solution to the problem. We hope you can work with us on that. I'm here to answer any questions too, if any of the members have them.
Sure, quick question. The MAC meeting, when was that? Was that pre-COVID, mid-COVID, or ballpark?
That was last year. The exact date escapes me. Is probably around June, July.
And I see a stack of other folks with questions. I see Matt, and then Patrick, and then Lynn.
Is there anything right now preventing the physicians from just saying, you know, I'll see you back here in 24 days or 30 days? Is there any reason that they can't? Physicians just can't do that? I don't know why it has to be included here. Is there there's nothing that prevents physicians from, if you've met with that group of physicians, they have the ability to have folks come back. So there's nothing that prevents them from issuing professional guidance on this.
Correct. Yeah, a physician could say, I'd like to see you next week because we need to do a wound debridement or a suture removal, or I'll see you in 30 days or 45 days. The doctors have no limits right now. And we're not seeking to cause doctors to see the worker every 30 days, the doctor could still exercise that discretion. What we're seeking is that doctors are having, at a minimum, contact with the worker every 30 days to ensure that work restrictions remain appropriate when workers are receiving time loss benefits. And that doesn't have to be tied to an appointment.
Thank you.
You're welcome.
And I see I don't have my ability to type and look at the same time, so I'm scribbling my notes on my legal pad as it goes. So if I'm staring at my lap, that's what's happening. So Patrick.
Thank you, Scott. Thank you very much, Elaine, for that testimony. There was a lot of discussion from the trial lawyers about the 30 days being sort of a unreasonable request, that you would lose something if you went more than 30 days and didn't go to the doctor. I was wondering, what happens if a worker misses an appointment? Would they be somehow losing out on benefit that they have under the law right now?
Currently, or if there was to be a 30-day a time loss piece where that authorization is being addressed?
I guess it would be if this was put in place, I suppose, because right now there is no restriction. It could be unlimited, it could be forever.
Yeah. I think that is why this is an issue that has that prospective and retroactive piece to it. And if we took LC 56 as it stands and then folded in what is being proposed by our side, you could have a worker who misses their appointment. They could still contact the doctor's office, and workers will cancel appointments, right? Things come up, life happens, but they could still contact the doctor's office to get updated work restrictions if the doctor feels that they remain appropriate. Alternatively, or even in addition, if the worker was unable to do that or the doctor was unwilling to address the work restrictions, then under the current proposal, that doctor could go back 60 days. So the worker could still receive those time loss benefits through a retroactive release. So really we see this as a two-part solution to what's a broader problem of time loss benefits being not addressed in a timely manner, but then also there being gaps. And so by extending the retroactive authorization time period, that addresses some of those gap problems.
Thank you for that.
And I see Lynn, looks like you put your hand up, but I see Tammy's hand up.
Just to reply to Patrick's question about what happens if they miss appointment, that happens all the time, especially with COVID. Appointments are canceled and rescheduled. Even the doctors, could be no fault of the worker. The doctor cancels and reschedules an appointment, and that doesn't stop time loss. However, I want to read to you ORS 656-242-4. If a worker fails to appear for an appointment with the attending physician or nurse practitioner authorized to provide compensable medical services, the insurer or self-insurer employer shall notify the worker by certified mail that temporary disability benefits will be suspended after the worker fails to appear for a rescheduled appointment. Not before, but only after, and only if they're notified by the certified mail. That's what the current rule is. Thank you.
And I see we have the date of the MAC meeting in the chat. Thank you for that. Any other questions? I saw that, I think it was Kevin was on the list too for SAFE. Sorry, I'm getting into your bargain unit work here, Teresa.
No, you're fine. No, I believe, no, he was signed up, but no, that we gave all the time to Elaine. So if there's no other questions for Elaine, we can move on to the next stakeholder. And that would be Kevin Anderson.
Good afternoon. My name is Kevin Anderson, and for those of you members that I haven't met before, I'm a partner at SBH Legal. We are a defense law firm representing Oregon and Washington employers and insurers, primarily in workers' compensation claims, but we also handle employment, longshore, and some other areas. My practice is limited to Oregon and primarily representing self-insured employers in the workers' compensation system. I've been involved with MLAC meetings for almost 10 years now. I'm our legislative and rule point person for our firm based on some of my prior work in the legislature. I don't have a lot more to add. I would agree with everything Elaine and Safe had kind of laid out about the negotiations and things going so far. I think probably to some of your surprise, one of the things I would actually agree with on Keith's point is that even he said we need MLAC's help on this issue. I have been involved with these meetings. I submitted testimony back in 2018 when the temporary disability issues were still kind of just in talking points. Over the course of 10 years, we've seen more divisive issues than time loss kind of come through MLAC, where both sides have kind of drawn a line in the sand and said, I'm not going to meet you in the middle. And thanks to MLAC's kind of involvement, forcing both sides into work groups and saying, don't just, have a meeting where you guys are talking past each other, actually work together and try and find something that everybody agrees can actually improve the workers' comp system, not just improve benefits to the worker or make things easier on the insurer or employer, but overall look at all aspects of what we're doing here and make sure it's actually helping Oregon's work comp program. I'm happy to answer any questions from the perspective of a defense attorney not involved with SAFE, but my experience is pretty consistent with what SAFE has laid out so far.
I have one question, if you know.
Go ahead.
We had heard that there are no remedies for workers that don't stick with their medical care. Is that true? If there's somebody that doesn't go to the doctor, is there any remedy to, stop benefits that they may not have rights to?
I think it depends on the case. I think both sides have talked about this requirement to treat every 30 days, and the way the rule's written, it's 30 days or longer with the permission of the attending physician. So an attending physician could tell the worker, follow up with me after you've had surgery. But if the surgery is for a denied condition, they aren't following up with the attending, they aren't following up with the surgeon, and there could be an open-ended work release, and the worker is just out there saying, okay, well, my doctor told me I needed surgery, I guess I don't need to do anything more. There's no follow-up with the doctor about, improvement or getting back to work or other things that can be done if the surgery's not proceeding for some reason.
Thank you for that. That answers my question.
Just two questions for right now. How often do these open-ended time loss assignments get made? Is this something that is common practice, or do the doctors usually put kind of I want to see you in this many days? I guess, this is such a large topic. I'm wondering about it sounds like it's very possible that it happens, but what is the probability of it? Is that even a gatherable number?
I don't know that I could get a specific number of cases that I've dealt with in 10 years, but it is something that pops up on most of my cases at some point. It varies mainly from doctor to doctor or clinic to clinic. Kind of as the medical advisory committee indicated, each doctor kind of had their own idea that, I thought I had to end it at 30 days or 14 days or whatever it was. Often doctors not involved with the work comp system and don't really know what they're supposed to do will just say, off work. And then it's not that they say off work indefinitely, it's that they just add subsequent examinations. And so it could be 6, 9, 12 months down the road, and we have an off work note from a examination, 2 weeks after the injury. And that's when we start, talking to the doctor and saying, hey, you've had them off work for almost a year now. Is there, something that we can do? But I don't think it's as explicit as the doctor saying, I never want this person to go back to work. I think it's more of an error of omission where the doctor just says off work and never thinks to reevaluate it and think, hey, can this worker benefit by going back to light duty, something, sedentary or light duty or, medium category work, something along the lines to help them move, get off the couch, remain active, things like that.
Thank you, Mr. Anderson. And this is kind of I'm throwing this out there, and maybe this is just way oversimplified, but with kind of speaking to the not necessarily knowing that there needs to be an end date, is this something that could even be solved with, adding an extra line into paperwork with saying reschedule time or reschedule date, just to kind of prompt doctors to even consider putting an end date?
I think so. We'd probably need input from the doctors on, how to get that information. But I think that was part of what led to the discussion between both sides of saying if we could kind of clarify, 30 days going back, 30 days going forward, or 60 days, whatever the number is, it makes one simple kind of analysis that's easier to educate doctors as opposed to right now where it's, you can go 14 days back or 30 days with an exception or this, making it very clear to the doctors of, this is what's expected of you, I think kind of helps, puts it back on the doctor to know what they need to be doing, not on the worker to tell the doctor what they need to be doing.
And then just one more quick question is, do we know who makes up that medical advisory committee?
Offhand, I don't know, but I'm sure it's something that we could get pretty easily.
Maybe kind of an open question about that as well. I don't know if there's, if SAFE would have that information or somebody at the division or, Jennifer Flood's office maybe as well.
We're putting it in the chat, so you'll see it shortly.
Excellent. Yes, I see things popping up in the chat, and I see a hand. I think Elaine had a question there or comment, maybe an answer to that, and then I see.
Yeah, I was just going to add to what Mr. Anderson said in response to Ms. Fullerton's question about having a line for doctors to just address work restrictions, where I think it becomes problematic is that doctors use different software and different medical chart technology to treat their patients and go through work restrictions. So we see a broad variety of chart notes coming from their own individual systems. And while you have one large system like Kaiser, who has a very standardized process with work releases coming up pretty routinely, there are many of our practitioners who just don't have systems set in place. Or at least they're not showing up in their chart notes that are being provided where there's an input for work restrictions that would prompt the doctor to address it.
Gotcha. And I see Lynn's hand.
Thanks, Scott. It's actually a question for Elaine, if I may. So as they talk about they being the trial lawyers, it seems to be a reasonable issue where if a doctor has said, well, I'll see you after surgery, that if that doesn't fit into the 30-day window, it makes sense that the doctor is still engaged in the thing. Is that something, if you all were to talk, as I hope everybody will, that you could come to some reasonable conclusion on that?
I think we're always willing to engage, and we've relayed that to the trial lawyers. You know, we're here to talk about solutions to what we see as a common issue, and so we're here and available. And again, you know, we're not saying that the surgeon who says I don't need to see you for 6 months needs to see that worker in 30 days. We're just wanting to ensure that there's regular contact, because you know, workers have variety of care needs and treatment needs, and not necessarily one size fits all works for individual workers who may have complications in their recovery or a speedier recovery. You know, we see a whole range in terms of how workers deal with their care and their recovery, and we feel it's really important that workers are having a regular and consistent communication with their providers to ensure that their care and their progress is tracking appropriately, and that they're not falling into a system where something's either improving or deteriorating and the doctor doesn't know, and that leads to a disservice.
Thanks. And that really does represent additional benefit to the workers certainly in terms of just having their visit paid for.
Having been through this whole process as an injured worker and having gotten anecdotal, you know, understandably so, but having been through the process, been given, you know, a no work release, and then a light duty release, and then back to a no work release, then to light duty, then fighting through an MCO and all of that, I find it really hard to believe that workers are not very engaged in their care. That was certainly not the case with me, and I was constantly pestering any medical person involved in my care and my case to try and get better, get work release, you know, move on with life, and was in crippling pain for much of the beginning of that. So there's an incentive already to make sure that I'm not just laying on the couch because I couldn't without feeling like I had a knife in my back with pain traveling down my leg. So I'm hesitant to just accept wholesale that this is the best thing for workers and that workers are not out there already doing this and engaging with their medical professionals as much as they possibly can to get better because they're injured. I mean, yes, there's some percentage of fraud, I'm sure, that would maybe be addressed by this, but there's a constant reminder that you need medical attention when you are an injured worker and cannot work. So I don't know if there's maybe some evidence of some kind that the management stakeholders or the folks concerned about that could bring forward. But I'm given my experience that sort of flies in the face of everything that I understand about the process. And I see that's not not something that needs to be addressed immediately. That's just sort of a thought maybe for next time. But I
remembered to unmute myself. So I'm hoping that Elaine and Kevin, you can help me out here because I feel like I might be missing something. I feel like everything that I've heard is that you want something more in the bill, but I haven't heard that you don't like what is in the bill. Am I understanding you correctly?
I think you're hearing both, because we have supported some parts of the bill and changes being proposed. Specifically, we agreed throughout the summer that denied claims should be excluded from the time loss requirements. We also had agreed that retroactive releases and the 14-day limit should be increased. Now, we had at our breaking point when those negotiations ended, we were at 30 days and the trial lawyers were at 60 days. And those negotiations could have continued, but they didn't. We also agreed to the additional notice pieces. We do have some issues with some of the more technical aspects of that bill, And we have a draft amendment that addresses those pieces, which we'd like to talk with the trial lawyers about and get their thoughts on our compromise solutions. So we're looking for that opportunity to engage and then revisit what we see as an important piece in finding a more whole solution to this issue of time loss.
I'm not seeing any other questions. I think we have one more witness on this. I'll let Teresa do the thing.
Benjamin Debney.
Okay, good afternoon, members. Thank you. My name is Benjamin Debney. I'm a shareholder at Wallace, Clorman, Keepner, and Bishop, and represent employers in Oregon Workers Compensation cases generally. And for those of you, you have not worked with me. I've been a lawyer 24 years, been doing workers' comp for 14. I was a staff attorney at the Oregon Workers Compensation Board. And so I've got a significant background in this. I was a claimant's attorney for a while. And I don't have a lot to add at this point, given what I've heard now. I have a lot of disagreements with what the trial attorneys had said, and am quite frankly insulted with clawing back, vilifying, with overpayments clawing back and seeing these things as vilifying employers when in that situation, the board needs to understand for overpayments, the worker was never entitled to them legally. It's not compensation. That's why it's going back to the employer. And other states, such as Washington, require workers to actually pay all of that back. So to say it's taking something away from the worker is a misnomer. And to say it's clawing back and characterizing, again, is not well taken. But my experience for what I've heard and from the board members going, hey, do you have some other experiences here? The open-ended time loss happens, again, what I see are the litigated or stuff that has been referred to me. So if there's statistics for all of the cases and how much of what I see is toward the edge of a bell curve or in the middle, I can't say. But what I do see and have seen over the past 14 years, mostly in the defense, is open-ended time loss in many cases. And often, as Kevin said, if you have all see the, I didn't have a Form 827, but there's a space that they can often say time loss from and stop, and they never fill out the stop date. And so as you have the example, we'll get one that's six months down the road, and although the worker could have been back to work, and they're entitled to time loss through that whole period, and that's where some of that problem comes in. And with regard to the open-ended time loss as well, 30 days to second that it shouldn't be infinite. I guess I was just searching for words. It just shouldn't be infinite, because what's the policy goal? How does that help the worker? How does that help anyone? If the goal of the workers' compensation system is to help workers get better and get back to work. I welcome, again, working together if the MLAC committee wants a work group or to discuss further, but many other disagreements that don't need to go on here. So I thank you for your time.
I guess maybe a quick question. I know we've heard from a lot of legal professionals. I guess, myself included, thrown into that bin. Is there anyone maybe kind of a step down? I hate to cold call Jennifer Flood, but I know that her office works a lot with workers sort of before things go thermonuclear, as if they haven't already because the injuries occurred. But maybe something about, are we seeing a lot of problems with doctors and, challenges to these issues kind of before they make their way?
Did he freeze up for you guys too?
Yes.
I'm going to assume he was going to ask me to speak. This is Jennifer Flood, Ombuds for Oregon Workers, part of DCBS. And from our perspective in talking with workers, it sounds easy to, just call and get that updated work restriction. We hear more. Of course, we don't get the calls from the workers where the system's working well, but most of our concerns from workers regarding medical services is being able to get in, or they've been recommended for some kind of treatment and they're waiting on the insurance company to approve. One of the things I wanted to bring up is that the current statute gives the insurer the ability to contact the doctor to verify an inability to work. So if the open-ended time loss authorization is there, the adjuster can call the provider, ask for the inability to verify inability to work, and if the doctor cannot verify that because they haven't seen the doctor, they have the ability of stopping time loss, as long as it was not within the workers, or as long as it was within the workers' control that they didn't. I'm saying that wrong. Unless it was not within the workers' control to see the doctor's office. So there are provisions in the current statute and the rules to kind of shore in those cases where it's an open-ended release and the worker isn't participating in their care. We usually hear from workers who are struggling to be able to get into the doctor, to be able to get those appointments. And I don't have data for you, but it is a very common concern for workers to get that communication in. I'm not saying that very well. I have a concern that if the doctor says, "Yep, we just did surgery, I'll see you back in 6 weeks," that injured worker then would have to get another authorization for at the 30-day mark in order to continue to receive benefits. True, with the retroactive 14 days, hopefully they could get in or get through to the office to get that bridged. But in the meantime, their benefits get interrupted. It creates issues when there's so much uncertainty. Some of the concepts that are in the bill that's actually before you, those issues come up all the time where workers are getting blindsided. They feel blindsided that their doctor had taken them off from work and then all of a sudden a med stat date goes way back and it's all considered an overpayment and is taken out of their permanent partial disability award. That permanent partial disability award is intended to compensate the worker for the loss of use function and inability of returning to regular work, but instead it gets eaten up with that overpayment of time loss. Maybe good claim or tighter claims management on things, but putting the burden on a worker to question a doctor's authorization just seems a little out there, and I imagine we would get several calls from workers not being able to accomplish that. And I do have that concern about medical providers' offices and more doctors dropping out of the workers' compensation system. I appreciate, I respect the providers that are on MAC, but most of the time these time loss authorizations, it's going through the office staff at the doctor's offices, and I don't know what kind of impact these changes would have on them. Does that address what you were going to ask me, Scott, when you froze up?
Yes, I believe so. I'm now having problems unmuting. Sorry. I see Patrick and then Lynn.
I had a question, and I think it was for the attorney that went, Mr. Debney, or anyone could answer this question. You know, when I read all the material before this meeting, the issue of overpayments, you know, I wanted to understand a little bit better what overpayments meant, you know, the word clawback and taking funds away from people, and this is their compensation. So even if maybe it was something, I don't know, it's money that they get. I'm seeing that no. I guess I need to know better what the overpayments mean, and that, when you say it's something they didn't have rights to, I kind of considered some of these things being put into the bill would be preventing there being overpayments and actually paying out amounts of money that shouldn't be paid out to begin with. And I'd like to understand that better.
I see Keith's hand up too. Is that just to answer the question along with Mr. Debney?
Yes.
Please, Keith, go ahead.
I would just say that in terms of overpayment, we've got a number of concepts in this bill. The most concerning, the biggest frequency and the biggest dollar amount that we see is where the doctor says in a couple months prior to saying it that the worker probably had reached maximum improvement. So the worker gets temporary disability up until the point that they reach maximum improvement. That's wage loss, as we commonly refer to it. After they reach maximum improvement, they get, if they have permanent compensation or permanent impairment, they would get compensation for their permanent impairment. The biggest, I would say by far, we've talked a lot about backdating work restrictions and open-ended work restrictions and things like that, and how that can contribute to overpayment, and how a worker should be more engaged and can prevent that. The biggest issue by far is having the doctor take months of wage loss back, or having the insurer take months of wage loss back, because the doctor says in hindsight, we could actually say that the worker reached maximum improvement a little while ago. The worker's going along through physical therapy, taken off of work, not doing unemployment because everything's still in flux, not seeking employment because everything's still in flux. And then they're told months after the fact that they actually had reached maximum improvement, although nobody told them. That can add up to tens of thousands of dollars of overpayment for a worker who's highly compensated. And that's really, when we talk about overpayments, if we really want to kind of rank the things in terms of importance in this bill, that's by far the biggest dollar amount and the thing that we see the most often, and the thing that's least under the worker's control, because they're not being told. They may be seeing the doctor every 20 days, and they're not being told that they've reached maximum improvement until the doctor agrees potentially with another doctor who says so. And that taking money back out of a worker's impairment compensation for their loss of function, and potentially a lot of it, potentially we're talking about tens of thousands of dollars here. We see that. Taking that back out when the worker has no control, that's really one of the biggest things we want to talk about in this legislation. With all due respect to the other folks who have recollected our discussions over the summer, that did not really get any traction or agreement, based on the fact that we were thinking that the 30-day cutoff, regardless of circumstances, was draconian. We didn't get past that impasse of saying, hey, just cutting off the worker in 30 days, regardless of what their doctor will say and do, regardless of what goes on, is not fair. We never got past that impasse. So that, when we talk about overpayments, that's really the biggest concern. Some of these other things can contribute. That's really the biggest factor, and really the most unfair one that we'd like to address.
So it sounds like seeing a doctor more frequently or getting that answer faster would prevent overpayments. Maybe not on a 30-day time frame, but more frequently. Maybe I didn't hear you. You might have froze up. I don't know.
The worker may be seeing the doctor every 30 days, but may not be informed that they reach maximum improvement until way after the fact. So that overpayment that I just addressed is not controlled by how often the worker sees the doctor. It's what the doctor agrees to once the insurer asks the question, or perhaps presents them with another doctor's opinion on the matter. And at that point, they can backdate the medically stationary date as long as as far as they want. The worker gets to backdate work restrictions 14 days. unlimited amount that can be taken back by backdating the medically stationary date. So this is a different issue. I mean, this is an issue that we really haven't talked much about. We haven't gotten hardly into this issue at all because most of the time is being eaten up by talking about backdating work restrictions or how far work restrictions can go once they're issued. And this is another issue that we'd like to talk about. We just haven't gotten past the issue of backdating work restrictions. So that's part of where we are.
This is Ben Debney. I was hoping to defer to Elaine because she has a little bigger picture with regard to the discussions that happened, and then I'm happy to defer to her for the perspective of how overpayments work and my perspective that it's not money they were entitled to. That's why it's being given back. Just like if you gave somebody too many months rent, you'd want it back. They don't get to just keep it because, you gave it to me. That's kind of what this is happening here. And yes, it becomes big dollars, and that's also why it's a big concern to us as well. But I defer to Elaine.
So I see a few hands here. I'm going to step in for just a second because I know that we have about 5 minutes left formally. Hopefully we can go over a little bit. I know that we have one more LC to address, and I believe Rep. Graber is graced us with time to kind of touch base on that. So I see a couple hands up. If we can make that really, really quick, because I feel like we maybe want to move on to LC 96 to get a little more in on that as well. Do I see kind of some thumbs up or some fist shaking? If that is a terrible idea, thumbs down. I see, and I do see Lynn, your hand up to go. Go ahead, Lynn.
Yeah, just very quickly before we leave LT 56. In the bill analysis, there are a number of questions that I think are very good questions that I would love to hear or see, probably in writing is easier, responses from the proponents. A lot of them have to do with clarity of the language, so that addressing them now would probably would be very helpful to the ultimate outcome.
I think that's a great idea, and I love written testimony because I have a little more time to digest it as well. So any other comments before we quickly shift gears to LC 96? Sarah, I saw thumbs down. Did you have?
Well, yeah. Can I just speak briefly? If we're going, I want to do LC 96. It's due justice and service, and I don't want to rush through it. So that's my concern. I do have other engagements, so I can't stay on, for an unlimited time, but I don't want to shortchange the discussion. So that is my concern.
No, of course, and I don't mean to shortchange discussion and rush a vote in the last 2 minutes or something after we're into overtime, but definitely want to make sure that the witnesses that have signed up are able to put in their piece. Tammy, I see your hand up.
I'm just wondering, how we're leaving this, LC 56, because they've asked for our help. It seems like they're asking for MLAC to ask the parties to go back to the table and just work out these few little dates. It seems like there's quite a bit that there's agreed upon and just a small amount that's not agreed upon. So I'm wondering where we're leaving that. Are we asking the stakeholders to go back and finalize these last few pieces? Is that the plan?
Before we address that, Teresa, or is there any kind of a deadline that we're mashing up against here on that, LC?
The only one really would be if it's the schedule. If it's not been scheduled for a hearing, to the best of my knowledge. I haven't looked at advisory agendas since we started the meeting. So that's really it. We can continue the conversation, or if the caucuses want to get together and formulate a plan that can be announced at next week's meeting, that works too.
I feel like there's a lot more to be said on this, and I would like to hear a lot more. I feel like the majority of the discussions on this topic has been dominated by something that's not in there, that's not addressed, which kind of frustrates me that we haven't. I feel like there hasn't been a ton of discussion about the meat of that proposal, and a little confusion on my part that as to why we cannot continue to discuss that LC, or why, if there is so much agreement on those issues cannot be moved forward on when they're silent onto the other concern. So I'd like to see some written testimony. I'd like to hear more input on that. So I'd say maybe, follow up with hearing a lot more on that LC next on Friday, possibly pushing further discussion onto that agenda. But love to hear.
Scott, may I ask just a rudimentary question? What's the harm in the stakeholders talking and going back to meet?
I wouldn't necessarily say that there's harm in that, unless we're sort of kicking that back to stakeholders as a way to sort of kill the bill when there's obviously a lot of things that are all agreed need to be addressed and are problematic to workers in the interim.
I didn't hear anything on either side about killing a bill. I heard a lot about compromise and a lot about working together, and I'm struggling to see why that isn't a good thing.
I think it's a good thing. I just question if we've been asking as MLAC for them to get together on a unified thing since 2018, more or less, and that hasn't been done. I'd be more interested on seeing what can be moved forward on, but that is my opinion. Do we want to maybe push it? I see Tammy. I'll let you go, but do we want to maybe push it until next week, put it on the agenda next week to discuss a little further, and then whatever we decide to do, we can ask folks to continue to work in that time and submit written testimony so we have more to review and can come into that a little more prepared, maybe? Go ahead, Tammy.
I've heard people say a couple of times they don't understand why we're talking about an item that's not even in the bill. And I don't really understand that statement, because having the worker go from seeing the doctor around every 14 days to all the way out to 60 directly affects the time loss. And that's the one that we have been talking about and have been having an issue about and asking OTLA and labor side to compromise with us on. The whole conversation is about that item. We have said previously a couple of different times that several of the other pieces we are more than happy to compromise and agree to some of those other things. And if we can iron out just a few of these dates and things, I think we can come with an LC that both sides want to vote yes on. So that's my take on it, Scott. That's my opinion, and I would like to see the two parties come together. I would really like to see them come together. I had expected, based on kind of the marching orders, we go back into the minutes from last February and March to lift. I expected to have a bill before us that all the parties agreed on and easy peasy to vote yes on, and we wouldn't be involved in this. Okay, I'm going to shut up now. I'm sorry. So it's just a little bit frustrating.
I know this is a contentious issue that was frustrating last time. I know, and we had a couple subcommittee meetings that were pretty aggressive and unpleasant as well at times. So I thank everyone for their patience and contributions. And I do see that we are over time. Do we have about 10 or 15 minutes?
Yes, so I think it's time to shift gears to LC 96. Holly Odell is the only, outside of Representative Graber, that's signed up to speak. But
Teresa, this is Rep. Graber. If Holly is here, I would like to give her the grace of going first.
Good afternoon, members of the committee, co-chairs. My name is Holly Odell, and I'm with SAFE Corporation. We got to meet last week, and I testified a little bit regarding the proposed presumption. There were questions from the committee at that time about the science, and the issue was whether there is significant medical evidence or studies that connect firefighting as an occupation and the incidence of cancers, specifically bladder cancer and cancers of women's reproductive organs. Last time, I didn't speak to any assessments that SAFE had obtained with regard to the medical evidence and the science. We spoke a little bit instead about how MLAC might choose to go about this, whether they would look to make a decision that cancers are so consistently caused by firefighting that these types of cancers should be presumed in all cases to be caused by firefighting, or if instead there would be reason to move forward for policy reasons with a decision that all cancers are caused by firefighting without or in the absence of medical evidence. SAFE had hired an expert witness to review what the state of the medical literature is. This is Dr. Rebecca Orwall. Dr. Orwall is an oncologist, and I know that's a little bit different than an epidemiologist. Both weigh in on the incidence of cancers, of course, from different perspectives. So Dr. Orwall had authored a report indicating that she had reviewed a number of studies, lots of studies over various periods, and also meta-studies, which are compilations of intern studies, and that she had found overall that she could not discover that the literature supported a significant correlation between the incidence of either bladder cancer or cancers of women's reproductive organs in firefighters. And we posted her literature review in our testimony last time, but didn't speak to it. After receiving the testimony from the Firefighters Council with the additional reference to 2 studies, we sent those studies to Dr. Orwall with the same request. Our original request had been to start with a blank slate, to start fresh, to have an open-ended, open-minded, objective approach to telling us whatever it was that she saw, and to let us know what her conclusions were in her review of the literature. So she reviewed the 2 studies that had been submitted in the testimony from the Firefighters Council, and then wrote back to us again. And we will submit this second testimony now of Dr. Orwall. It turns out that Dr. Orwall had already reviewed the 2 studies, meta-studies, that are indicated in the firefighter's testimony as part of her original review. So she had reviewed an entire bibliography and annotated the bibliography of lots and lots of studies. And that's what she used to come to her conclusion that she wasn't able to identify a significant correlation between the occupation and the cancers for this particular type of cancer. We know that these studies were selected in particular to support causation and correlation, and so she looked at them in particular. And she wrote back again, and she indicated that even looking at these studies that are, the best possible or the strongest potential evidence of correlation as submitted by the proponents of the bill, She still thought these studies, even as she re-reviewed them, even these 2 studies alone in her mind do not support a significant correlation between cancer of the bladder or women's reproductive organs and firefighting. So again, she re-reviewed these 2 studies before she had reviewed them with lots of other studies, and now she reviewed just these 2, but thought it was her opinion, her expert opinion, that just these 2 alone do not, even on their own without contrary evidence, support that conclusion. There were 2 reasons. The LaRoche report, she said, included actually both positive and negative studies about bladder cancer. So some of the studies in the LaRoche report supported a connection between bladder cancer and firefighting. Some of them said that bladder cancer occurs less often in firefighters than in the general population. And she said that in all but one report that LaRoche reviewed, the statistical evidence is very weak for any conclusions, meaning that any conclusion could just be by chance. She also said that LaRoche, the author, had indicated that caution should be exercised in interpreting their own results because there was low methodological quality of the SRs reviewed. She also looked at the report by Jalalian, and she was not able to say that that would be support of a significant connection between cancer and the occupation of firefighting for bladder cancer and cancers of the female reproductive organs. Apparently, the Jalalian study included in its analysis studies back to the 1950s when many people smoked. And the majority of the studies reviewed by Jalalian weren't conducted in the U.S. So she said that while on its face that study, if you read it quickly, might show a connection, it turns out it's not applicable likely to the United States or to the current time, the recent years, the recent decades. So she provided a lot of information about how to understand science and scientific studies, and we'll attach her new report as testimony. Thank you.
Thank you. And I know Teresa said, I think Rep. Graber has some time as well.
That is correct.
Thank you. For the record, my name is Dacia Graber, State Representative for House District 35. Just listening to that man, beauty is in the eye of the beholder, I guess. It is fascinating how we can all look at the same studies and come up with different conclusions. I'm curious how those studies will eventually align with the 20% general causation over that firefighters have over the general population that SDAO's doctor found. But anyway, that's an aside. I don't have any prepared remarks. I have some scribbled notes, and I'm going to try to stay true to. So I've been coming to these meetings and sitting through all 4 hours, and I give you all credit for hanging in there. I really appreciate this work. But I've been coming for a few reasons. One, obviously, because I'm the chief sponsor of both these bills, and 2, because my North Star is standing up for and protecting workers. It's also ensuring that the very lucrative system that we trust to take care of our workers is doing just that. I'm confused and disappointed today by the assumptions that I've heard that the workers from the workers' comp industry that our workers are bad actors or not injured enough or not worthy of this protection. And I would remind everyone that the financial reality of our state worker comp rates have been dropping annually over the last decade. And that reflects excellent business practices and is something to aspire to. At what point are these reserves about the detriment of our workers? In this case, we're not talking about a sea change. We're talking about the very most injured people, and in this legislative concept, a few cancer cases. It goes without saying, and workers are not lazy, and they are not inherently gaming the system. Firefighters are not manipulating laws to cover shadow illnesses. No firefighter wants cancer. They're facing devastating and life-altering and oftentimes life-ending illness. And while we wait for doctors and lawyers to battle over what's the science and what study relates and what's right, firefighters are dying. I can't be more blunt than that. And we heard a workers' comp advocate state last week that this is not about people. My question for MLAC If this isn't about people and the wellness and care of our state's workers, then why exactly are we here? So at the end of the day, from where I sit, I guess I'm asking this committee and everyone in this hearing to remember that we all, from insurer to firefighter to legislator to worker to lawyer even, are in the business of serving and helping people. And I implore you, as you consider your decision, to remember the people who are counting on you to stand up and be their voice when they don't have that choice. So again, deeply appreciative. Thank you for all the time. This is a lot. This is heavy loaded stuff, but please remember, I see the good work that's happening, and I implore you to remember the mission. Thank you.
Thank you. I know that we're way over time, but I like the ending on an optimistic note, you know, rebalancing us with the common values. I know I'm a broken record on that, but this is about people. This is about, obviously, cost matters. It is important, but this is a policy advisory board. So I thank you for that. As we are way over on time, I would suggest that we adjourn. Obviously, we have tons more information that we will need from folks. There's a lot of talking, I think, in the caucuses that we need to do. I'd love to follow up with some folks, members of management and others. I'd love to see some more written testimony, especially centered on these common values on MLAC. You know, they're on our website and our handbook. Is there any objection? Is there anyone who feels that we just absolutely have to go another 5 minutes or anything like that? This is my trial run as co-chair. I hope that that's okay, and want to take us back. I know we had a great success on LC 38, so you know we can go back on that too.
Actually, Mr. Chair, I can just mention the two other bills that are coming forth that may be up next week with the co-chair's blessing. So that's all I have. So those bills would be Senate Bill 1585 and Senate Bill 1560. So members, we will get background information to you on both of those as quickly as possible, along with the minutes from last week's meeting, perhaps this week, today's meeting as well. So we'll get them to you as soon as we can. And I'm done, Mr. Chair.
Thank you so much, staff. Again, thank you everyone for your patience, especially my technical issues mid-meeting. I do appreciate the work that everyone does and the expertise that everyone brings to this. I know it opens my eyes to a lot of things. You know, I have my experiences I bring to the table, but I know, you know, Tammy and others, you bring great experience and understanding of these issues, and I really appreciate it. So want to thank everybody for that, and step down off my soapbox and back into my driver's seat here, and you know, head on to the next things, and look forward to you know, meeting with you next week.